and how values can change depending on the community that you are in.
First as a Black woman, and then as a defense attorney.
You care about defending.
They're cross-section because there's an obvious group of people, that distinct group that is missing.
That language that you should be using, because that's what the law says.
Currently, because of the overwhelming media coverage, any potential juror may have already formed an opinion about the case.
Members of the jury, welcome to our August conversation, Jury Duty Unmasked. Porsha-Shaf'on, how are you doing?
I'm holding steady. You know, I feel like every live I say the same thing because every live I am really holding steady. I am trying to keep my head above water and wade the waters.
Good.
How are
Glad
you?
you're holding steady. I'm doing well. It's been a good summer. I'll share a little bit about what we've been up to this summer. But before I do, I just want to remind everybody who we are. So we are the Juror Project. Our mission is clear. We are working towards ensuring that criminal jury trials across America accurately reflect the communities where the trial is taking place. And when we say reflect the communities, we mean in every sense of the word, right?
That's
we think
right.
our juries need to represent the beautiful diversity of race, diversity of perspective, diversity of experience, because the research is really clear. When you have more diverse and representative juries, you actually get fairer trials. And everybody should support that concept of fair trials. So we are excited for joining us for this conversation. And just want to make sure you remember what we are up to and who we are. Porsha-Shaf'on, give me one of your highlights from the summer.
One of my highlights, so a personal highlight was I went to a 9 a.m. banger. For anyone out there in the audience, members of the jury, if you are over 30, a 9 a.m. banger is where it's at. So literally, we were partying at 9 a.m. I think another highlight that I have is I went to a party inside of a zoo and was literally having a cocktail next to some lions. So that was pretty dope.
That's amazing.
What about yours? I think I know what yours is. See if we on the same page.
Yeah, I got to teach in Europe this summer. I was in Vienna teaching a course called Comparative Juries. So we were looking at the American jury system and comparing it to some jury systems of other countries. And it was just really nice to interact with the students, focusing on juries, which you know I love. So that was a big highlight for me this summer. What did you think I was going to say?
I'm very glad that you did that because I 100% thought that you were going to talk about when you wrestled an alligator. I don't be trying to make the members of the jury think that we out here leading completely different lives, Will. Tell these people if they have not seen online how you went for a morning run. Also, we don't run, but shout out to those of y'all members of the jury that do. Will was out here wrestling the alligator. Tell them, Will.
Listen, an alligator was running on the levee while I was also running on the levee, and no one would come and help. I called ASPCA, Department of Wildlife and Fisheries, non-emergency 911 call, and thankfully I have good neighbors, and he got his rope, I got mine, and we tied it up, threw it in the back of my truck, and then released it by the canal right by my house. And my wife was upset that we released it right by the canal in front of our house. She's like, why didn't you take it like a mile away? Like, why are you bringing it back right to our front step, basically? So
I love that was his issue and not why were you out there wrestling the alligator?
Right. We're going to have a conversation today about grand juries, but before we do,
not about you wrestling alligators. We definitely are going to have a conversation about grand juries.
Another highlight I just want to share with you all, the Juror Project is finalizing an amicus brief to be filed in the United States Supreme Court. And this is, of course, related to a jury issue. There was a man in Florida who was convicted of a crime by a 6-person jury. And he is appealing his conviction, saying when the framers wrote jury in the Sixth Amendment, as well as in Article 3, Section 2, they meant 12 people. So the fact that he was convicted by a 6-person jury, he's arguing is an unconstitutional conviction. And so we are writing an amicus brief, and that's just a type of brief that gets filed to a court by, third parties who, aren't officially part of litigation, but they can support either side, saying, hey, this is actually a good argument. Here's why. This is why we're interested in this case for whatever reasons. So we are supporting the person who was convicted by the 6-person jury, because we know 12-person juries more accurately reflect and represent the community, and that's what we're about. So we're supporting his appeal to declare 6-person juries unconstitutional, and I feel good about his case. This is the second time we've actually filed an amicus brief in the United States Supreme Court. It seems to be once a year, which is a great pace for us. So I just wanted to share that as well. Whenever we can get our name in front of the Supreme Court, that's a pretty cool thing.
Absolutely. That's so amazing. I'm really excited.
Thanks. Yeah. What is a grand jury? And give me the kind of most basic backdrop leading up to like what a grand jury is and what role do they play, if any, in a case?
Of course. So a grand jury is literally just members of the community. Members of the community come together and they listen mostly to the prosecutor's case. Now, members of the jury, members of a grand jury do not decide guilt or innocence. Their sole purpose is to decide whether or not there is enough information for the case to move forward. I know many of you have heard the statement, it is so easy to present the case to the grand jury, or it's so easy to get an indictment that a prosecutor could indict a ham sandwich, right? And so, because really it is a secret proceeding. That's one thing y'all should know. So the individual that is being accused of the crime does not have a right to know what evidence is being presented in the grand jury, what witnesses are testifying in the grand jury. The accused has no right to be present in the grand jury unless they are testifying. Now, the testimony and individuals and evidence that is presented in the grand jury, the accused finds that out later. But at the time of the proceeding, the grand jury plays the role of an investigative body. So they're mostly listening to the prosecutor's side. They're listening to the police officer's side, and they're determining whether or not there's enough information to go forward with the case. Do you want me to talk about true bills and no true bills, or we want to do that later?
Not yet. I want to ask you, is there voir dire for grand jury? Because when you're selecting a petite jury or a petit jury, like attorneys are asking questions. So how do the grand jurors actually get seated?
So in New York, the grand jurors receive a summons specifically for the grand jury. So there are no attorneys that are asking questions. These individuals are members from the community. They receive the summons specifically for the grand jury, and they are ushered into a room. At any given time, there could be as many as 5 different grand juries going at a time, hearing cases to see whether or not there's an information to go forward. But it is a huge difference between a petit jury, because a grand jury, you've already noted, attorneys don't get to ask questions. The individuals are not selected by the accused or their advocates, their attorneys, to sit on the grand jury. They're literally members of the community that have received the summons, whether it be in federal court or state court. They receive the summons to appear for the grand jury, and that is where they're going to be for several weeks.
Got it. Thanks for that. I want to bring some numbers into the conversation. So grand jury, like in the name, it suggests that it's larger in size. And typically grand juries across America can be anywhere from as few as 9 people. I think we've seen as high as 23. I believe in this federal system, it's typically 16 to 23.
Yes.
In Louisiana, it's usually 12, but it doesn't have to be unanimous. That's another kind of unique thing, that the grand jurors don't have to agree on whether or not there's probable cause for a charge. Before we continue this conversation, we had a quick question from somebody that was watching about where do they do 6-person juries. There are about 6 states that do 6-person juries. So the case that we're talking about, the man who was convicted, his last name is Keon, Kian. He's out of Florida. So Florida has 6-person juries, except for capital cases. And the other states that allow 6-person juries are Arizona, Connecticut, Indiana, Louisiana, and Massachusetts. In Louisiana, I'll just say 6-person juries are when you have a 6-person jury, usually when it's a lower level felony. If it's a more serious felony where the person can be sentenced what we call at hard labor, which is exactly what it sounds like, because we have Louisiana State Penitentiary, Angola. It's a 12-person jury. And you should know that 6-person juries have largely been introduced in states for efficiency's sake, like to kind of move things along. And we have talked about this before. Justice doesn't have a speed, right? So whenever you see, legislators or administrators saying, hey, if we do this, cases will move faster, you should be concerned about that, because having time to ensure that the appropriate person is held accountable or the appropriate person is acquitted, you don't want to rush those types of things, because we're dealing with folks' liberty and their freedom. I hope that answers the question.
So, Will, just getting back to the grand jury conversation, one thing that I want to ask you is, in terms of the grand jury, we talked about what the purpose is. We talked about the numbers, but I want to talk to you. I want to ask you, have you ever put a client in the grand jury?
We don't do that in Louisiana. I remember it happening in New York when I lived out there and worked out there, but it's not something that we do in Louisiana. And I want to hear how you actually even know that your client is potentially being investigated, because, my practice is we don't necessarily know that the grand jury is convening, is being presented, information for potential charges. So curious how that kind of works in New York.
So in New York, our clients are, more often than not, there are limited occasions where a case is put in the grand jury before a client is arrested. But more often than not in New York, an individual is arrested for a felony a felony crime, right? And so when an individual is arrested for a felony, if no bail is set on them, the prosecutor has 180 days to put the case in the grand jury. And every single time we have a client that is facing a felony charge, we say to the prosecutor, our client is going to testify. If you put this case in the grand jury, our client is going to testify. And so, because we put the prosecutor on notice that our client is going to testify, we find out if or when the case is being put in the grand jury. So so that's the way that it actually happens in New York. I know that more often than not is not the way it happens around the country. Members of the grand jury, we're actually seeing it right now in Mississippi, right, with the Nolan Wells case. It's my understanding that the prosecutors, before making an arrest on anyone, the prosecutors claim that they have put the case in a grand jury. So I want to note for the members of the jury that one way to sort of absolve prosecutors of responsibility, right, with criminal convictions is they'll claim the community doesn't want this case to go forward, so we're not going to make this case go forward. So in the Nolan Wells situation and in other cases around the country, particularly when it deals with police officers, before someone is arrested, a prosecutor will put the case in a grand jury and allow the community to decide whether or not the case will go forward.
Got it. Thanks for that. Do all cases start from a grand jury?
So in New York and in many places around the country, no. An individual is deprived of their liberty first. A securing order, meaning whether or not a person has bail set or is released, that happens first. And then a grand jury is convened to make a decision about whether or not a case should go forward. But also sometimes that's dependent on who the person is. And I think we have, as a community, seen what that can look like when you are a government official, because you've been talking about this for weeks now, in terms of what's happening in New Orleans.
Got it. That's good to know. And so what I'm hearing, and just want to echo, is in the United States, there really are kind of two ways people can be formally charged with a crime by a prosecutor. One is called a bill of indictment, and that's going to be something that comes from the grand jury.
Correct.
Or there can be something called a bill of information, which is another charging document that the prosecutor can simply present themselves. In Louisiana, the big difference between those two documents is if the crime that is being sought to be charged has a punishment of life without parole, it has to be secured via a grand jury, via an indictment. Other offenses, other felonies don't have that requirement. The bill of information can serve as the charging document. But here in Louisiana, you cannot be charged with, in Louisiana, a lot of our life without parole crimes are going to be, your rape, your aggravated kidnapping, your murder, things, more serious felonies. Those have to go through a grand jury. But if you're charged with, let's say, simple possession of cocaine, which is a felony, that can be filed just by a bill of information from a prosecutor.
Got you. So I have a question. So we have been talking about grand juries generally as they pertain to the community, but you have been talking over the last few weeks about sort of the way that the grand jurors have been treated in New Orleans and sort of the way that the grand jury proceedings have happened in New Orleans. So the first thing that I want to ask you is what has set the situation in New Orleans, the grand jury proceeding that has been sort of in our media over the last few weeks? Like, what sets that apart from the grand jurors that could get convened every single day in our country?
Yeah, so a lot of people may have heard New Orleans grand jury a month or so ago indicted our attorney general for counts of malfeasance in office, as well as public intimidation, for letters that she sent to elected officials in New Orleans, essentially suggesting to them that if they continue their current course of conduct, they could be potentially charged with violating Louisiana's usurper laws, right? Threatening prosecution. And if you're convicted of a felony while you hold elected office in Louisiana, that leads to your removal from that office. Members of the grand jury were probably exposed to this information to the different news outlets. And one of them might have been like, hey, this seems wrong, right? And there were some elected officials who had received the letters who were saying, listen, we're not going to be intimidated. We're not going to be threatened. And if you take the language of the individuals who received the letter, and then you look at the statute of public intimidation, it's not hard to see like where there might be some overlap between the experiences that the alleged victims were saying they were going through these letters and what the statute requires for the offenses that they ultimately charge the attorney general with. What is unique in this case is it wasn't the district attorney himself who presented, one of his assistant district attorneys presenting to the grand jury. The grand jury used their own investigative powers. And that's a really unique function of a grand jury. They can launch their own investigations when they have reason to believe that an offense has occurred. And so I can only imagine that there were grand jurors who saw this news unfolding, hearing about what the attorney general was doing, and ultimately did an investigation. So what that means is they have subpoena power. They can have people come and testify in front of them. They can subpoena documents, right? They can have those letters officially provided for them to review. And then after the assembly of all this information in their investigation, then they would have a conversation about whether or not they believed there was enough information, also called probable cause, to bring these charges against the Attorney General. So that's what has happened. She was charged, and then the charges were ultimately dismissed, which is a whole other conversation. But it's just really unique. I couldn't find any recent examples of grand jurors launching their own investigation. A lot of indictments are initiated by the prosecutor's office.
So, members of the jury, one of the things that Will mentioned was that the grand jury can function as an investigative body. So I just want to speak to you about just regular, schmegular, everyday prosecutions, right? So we talked about prosecutors having someone arrested for a felony and then convening a grand jury to make a determination about whether or not that felony can go forward. One of the things that Will just had noted was that the grand jury is an investigative body. So what that means for you as a community is if you are called to a grand jury, right? And remember, the grand jury is a secret proceeding. Remember that the prosecutor is the person, right? This is their stage. This is what they're doing, right? And so more than likely, you are only going to hear from the prosecutor and the evidence that they presented. Remember, if you are called to serve on a grand jury, you do have the power to say, hey, was there a video? If there is a video, I would like to see it. Hey, was there X person there? If that person is there, I would like for them to be subpoenaed so that I can hear from them. Members of the jury, if you are called to a grand jury, you have the power, right, to ask for more information. You are not an empty cup just waiting to be filled. You are welcome to ask for more information. Will, did I get that right?
You did. And I also want to just remind folks the length of time that grand jurors are actually serving. So it can be a 3-month period, a 6-month period, but it's not every day. It's usually 1 day a week, like every Friday or every Monday, whatever it might be. And the reason why I bring this up is I was really frustrated when our elected leaders, including our governor and attorney general, were describing these everyday New Orleanians who volunteered their time to serve on the grand jury, to do this important civic duty. And they were called corrupt. They were called a kangaroo grand jury. They were just the ways in which our elected leaders were very dismissive of the integrity of the grand jurors themselves, with absolutely zero evidence or information that would justify this labeling of corruption, right? I can imagine for the attorney general and the governor that it was very surprising and shocking and unbelievable that a grand jury did in fact bring about this indictment. And I agree, it is unusual. But instead of immediately coming out and attacking the grand jury, why don't you just prove your innocence like every other defendant in the state of Louisiana? And what was really concerning is in this matter, what was on display for the whole country to see was that we actually have 2 justice systems in the state, one for the attorney general and one for everybody else. And when I say that, I'm being serious because I've represented people in New Orleans since 2013. And there is a procedure with which to get your cases reviewed by the Louisiana Supreme Court. You argue something in trial court and it doesn't go your way, you bring an appeal to the next level, right? After you make your argument in the appellate court, it doesn't go your way, then you bring it to the Louisiana Supreme Court. So imagine that I had a client that's charged with a crime that I think is bogus. I can't just file immediate. I don't get to skip the trial court. I don't get to skip the 4th Circuit Court of Appeals here in Louisiana. I don't get to go right to the Louisiana Supreme Court. And the fact that she was able to do that, right, demonstrates these 2 justice systems in Louisiana. And then additionally, I have represented people who the alleged victims contact the prosecutor and say, these charges are not right. Like, I don't want to go forward with these charges. You need to drop these charges. And the prosecutor proceeds anyway. That's not what happened here. The recipients of the attorney general's letters, right, they wrote their own statement or letter to the special prosecutor in the case and said, we don't want these charges to go forward. And the special prosecutor dropped the charges. It would have been so much more badass if the attorney general would have gone through the process, would have had her arraignment, would have had her motions hearing, would have filed the motions to get the indictment quashed, which it probably would have been quashed. Say it wasn't, go to trial and win. Like, use the process. If you are the top prosecutor, right, use the process. And so I was just really disappointed, not in the outcome, but the way in which the outcome was secured, which, there was nothing but favoritism applied. And if we had the same presumption of innocence that the attorney general received as applied to everybody else who gets accused of a crime, we would have a very different criminal legal system.
Absolutely. And it's also before I make my point, Melody, thank you so much for your comment. Melody said the characterization of New Orleans grand jurors reminded me of the attacks on the poll workers in Georgia. Preach, Melody. This has a chilling effect on civic duty. Absolutely. And that's really why we're doing this IG Live, right? It's why we wanted to, let, everyday community members know that this does feel right. This does feel wrong. It feels scary, and it makes it feel as if public officials are above the law when, we have represented individuals that are not politicians or public figures who've had to go through the grueling process of the criminal legal system with none of the presumptions of innocence that this elected official has had.
Yeah, and we don't need to spend any more time about the attorney general per se, because I think we've talked a lot about it. But I do want to share that we had federal officials, state officials who were calling for an investigation into these grand jurors. And the Louisiana Association of Criminal Defense Lawyers created a committee to provide free resources for the grand jurors. And there was a hotline that they could call, because imagine a scenario where you have just finished your tour of a grand jury service, right, for however many months it was. And then you get a knock on your door, and it's law enforcement, and they want to investigate you, right? How can we, with the Juror Project, encourage people to serve on juries, knowing that the very people who have served on a grand jury are now subject to potential investigation, right? It's just very contrary to how we promote civics in our country. And it is absolutely ridiculous to try to investigate the grand jurors. And they have a lot of protections, right? Everything that happens in that grand jury room is confidential, and it is not something that can be interrogated by the public. The grand jury indictments are, get reported to the public, but what happens in those grand jury rooms are fairly confidential. So I'm really thankful for the Louisiana Association of Criminal Defense Lawyers for providing that resource for those grand jury members. And I hope that they're all able to take advantage of it.
Absolutely. Absolutely. I could not agree more. So I have a question for you then. So let's say that there was this practice of putting our clients that are accused of crimes in the grand jury. Based on what you know, would you be open to putting your clients into the grand jury?
I'm not there, right? That makes me nervous, right? So usually in a regular case, my client testifies, I am there to object to questions and kind of serve as their counsel. In the grand jury room, I, as a defense attorney, aren't allowed to go in there. So I probably would not do it, only because I don't have the experience doing it. I know you have, and I know you've actually gotten cases, I don't want to say thrown out because that suggests that there was a case, but you've had indictments prevented from, excuse me, let me use the terminology. You have allowed or helped facilitate the grand jury to vote no true bill on an indictment.
Yes. And to be fair, that was somewhat of a loaded question, right? Because I think it presumes that sort of this is a fair playing ground, right? And I think that I want to be clear to those individuals that that are watching this live, that it is not lost on us that this is imbalanced, right? And this is unfair. But oftentimes, I want to head note that people don't want to testify and people don't want to participate in a grand jury proceeding because it is very clear to them from all of their life experiences that this is not going to be a fair process. And what has happened in New Orleans only reiterates that, right? Only reiterates that there are individuals based on their status that appear to be above the law. But what I don't want you to walk away from this conversation with is the idea that I shouldn't participate because of imbalance. No, right? You should participate in an effort to keep this balance. And excuse me, not keep it balanced, to make it balanced. And so I do want to encourage our community members out there, when you get those summonses, do not throw them in the garbage. I know it feels as if, what you're doing may not be heard or seen, but it absolutely is. Even if you are not on a petit jury, if you sit on a grand jury, you can still save someone's life. Will, have you ever heard the saying that the grand jury can be a shield and a sword?
I don't know if I have. I understand the shield concept, and I guess I understand the sword concept.
Can you talk to us about what your thoughts are, what that brings up for you?
Yeah. So obviously, when we think about, let's say, a knight, you got a shield to protect from attacks, but then you also have a sword to make your own attacks. And when you apply that shield and sword analogy to a grand jury, I can see the shield function of a grand jury is to ensure that the government isn't arbitrarily trying to go after its citizens. I can also see the sword analogy as members of the community assembled in that grand jury to go after individuals who they have reason to believe has committed harm against the community, right? And so there can be these dual functions, right? Serve a check on the government from abusing its power and going after its citizens, but also being another investigative body to identify if there have been actors committing harm against the community, and then having conversations about what accountability should look like if that person was in fact, convicted of a crime for committing that harm.
Absolutely. There have been, and we've spoken about this on many lives, right? There are very recent examples, and I'm talking about 2026 examples where community members have really acted as a shield, right? From, politically motivated prosecutions. They've acted as a shield and they have acted as a sword, really, stopping these things at its head. Remember when we talked about the impressive and incredible grand jurors, the fearless grand jurors in Washington, D.C., right? How our government officials, our prosecutors were doing everything they could to convict the individual that was accused of throwing a sandwich at law enforcement. And they weren't able to do that, right? Community members said, this ain't that. Community members said that you are not going to prosecute this person for this. We've seen it in the food not bombs cases, right? Where community members have said, you are not going to throw the book at these individuals that are just trying to feed community members. So we've seen it in multiple instances across this country where grand jurors, everyday, regular, schmegular people have convened to protect us from political persecutions.
Porsha-Shaf'on, you at the top of this conversation, you reminded the audience of this, I think, phrase. More lawyers are probably familiar with it, but the idea that you can indict a ham sandwich, and it just tees up so nicely to this example you're talking about in DC, where if we continue that thought, right, you can indict a ham sandwich, but not the man who threw one, right?
That's right. Oh, Will, that's funny. I didn't even clock that. I didn't even clock that.
For the shield reference that you're making, there were multiple grand juries in Washington, D.C., where folks in D.C. were being charged with assault on officers or obstruction of justice, whatever it might be, for the demonstrations that they were participating in. against ICE or CBP, whoever it might have been. And members of that community said, no, this is not a crime. And you're not going to be charging our community members for doing something that is within their rights. And we have seen Jeanine Pirro, who's the U.S. attorney out there, fail a good number of times in getting indictment because the community there is not agreeing with a lot of these politically motivated prosecutions. And I don't have all of the details, but earlier today there was some news that Jeanine Pirro has called some type of a special grand jury to do what you were talking about a little bit earlier, Porsha-Shaf'on, is this investigative body and the investigative power. And you've named the strategy behind that, and I just want to make sure we're underscoring it for this example in DC. With your example about Nolan Wells, the investigation into Nolan Wells' death, the strategy from a prosecutor or district attorney is not to say, hey, I'm not bringing charges, because if the district attorney says I'm not bringing charges, then the district attorney gets attacked for not bringing charges. But if the district attorney says, hey, I'm putting this matter in front of the community who's represented by these people in the grand jury, and the grand jury decides not to indict, then there's insulation from any blowback that might come from it. Although, and I'd have to check if in Alabama, if, is it Alabama or Mississippi? Sorry, I'm forgetting. Mississippi. If the types of charges people would want to see in this case can actually be charged by a bill of information, or if they have to be secured by a bill of indictment. Now, in Washington, D.C., Jeanine Pirro has been, there's been reports that she's assembled some type of special grand jury for indictment purposes, for investigation purposes, right? It has the same strategy, right? Where if the grand jury comes out with this investigative report, it insulates the criticism of the report because it's everyday people who serve on the grand jury, and it's not the Department of Justice or the U.S. Attorney's Office who is issuing this report, whatever the investigation she's expecting them to do. And the timing is interesting, right? Jeanine Pirro has been getting a lot of criticism for not, bringing charges, securing charges against the Olympian who is accused of doing something to the reflecting pool, and in multiple other cases, right? But also, the midterm elections in this fall, right, can very easily be influenced by whatever report might come from the special grand jury, if that's how they're going to use it. So it's really unfortunate to see the ways in which the Department of Justice has become this prosecutorial arm of the White House and these politically motivated prosecutions, when we have other things that need to be focused on for the benefit of all Americans when it comes to public safety and communities' abilities to thrive.
Absolutely. And you just sort of touched on the timing of the convening of this grand jury. Trump has been criticizing Jeanine Pirro's inability to secure essentially what folks have called like low-hanging fruit indictments, right? Like it should be really easy to get indictments on many of the cases that she has put into the grand jury, but she has been unsuccessful because thankfully community members have acted as a shield against her political prosecutions. But what is interesting is that she has now convened this special grand jury. We don't know who these individuals are going to be that make up this special grand jury, right? And one of the things that you always say is it's important that the community members have, what is it that you say about the process and community members feeling good about the process? I'm ad-libbing and failing. But you say,
I talk about like having trust in the outcome because we have faith.
Why can't I get the word trust out when it comes to our government? That's what I meant. That's what I meant. See, my brain just wouldn't even get the word trust in government.
Not even a synonym.
It couldn't even. It wasn't
an
even.
Adjective you would never use.
I hear you say it all the time, but it wasn't connecting. Absolutely. Yeah. I mean, but that goes with any of these processes, right? Like when we are not confident in the process, when we don't trust that the process was fair, it really does make it difficult for us to trust in the integrity of any of our governmental processes, right? And that's why we thought that this conversation was so important tonight, right? Um like Melody said, these types of situations where everyday citizens are doing exactly what we asked them to do, which is getting a summons, right? Getting a call to action and answering that call, right? They did exactly what they were asked to do, which is investigate this situation. Or they did what they wanted to do, which was investigate this situation, right? But
That's right. That's right.
there was nothing to indicate. What I also found interesting in all the research in what is happening with the grand jurors in New Orleans, what I did find interesting is in all the talk of, the backlash that happened after this grand jury proceeding, there's literally nothing to indicate that any of the grand jurors in fact acted improperly. That's
Right.
the more interesting piece in all of this. It didn't matter what article I read. I've listened to all of your commentary. I've listened to other people's commentary. I've read articles on this. I have not seen one person actually say that, unless I'm missing something, that the grand jurors did something improper during their investigations. I know people didn't like the outcome, but if you know something different, Will, because you are boots on the ground, let us know.
Looking for my fans. I like to line dance.
You are you do like to line dance.
So, there hasn't been anything presented that the grand jurors did something wrong, despite all of this improper characterization by some of our elected officials. It really rises almost to the level of defamation of character. But putting that aside, I want to remind us, sticking in DC and the Jeanine Pirro in the U.S. Attorney's Office, right? These politically motivated prosecutions don't have to happen. And let me break this down. So remember when President Trump wanted the Virginia U.S. Attorney to indict Letitia James and James Comey.
So you beat
that
us to the
career.
But Will,
Yeah.
before you get into the mechanics, can you explain to members of the jury and me what a political prosecution is? What do you mean when you say?
Sure. Yeah. So prosecutions are supposed to be motivated by instances of harm that's been committed against the community. There's an obvious person who has been victimized, who has had harm committed against them, and that's supposed to be kind of the origin story of the conversation of what accountability should look like. In our American criminal legal system, our accountability looks like using our criminal legal system. You have hearings, you have trials, and then we use the carceral system as the main accountability tool, despite overwhelming years of demonstration that is actually not what is providing or creating public safety. When we talk about politically motivated prosecution, that's very different than what I'm talking about. The first example we could, and I'm making up this term, we could say those are, I don't want to say victim motivated, like they are motivated by trying to redress harm that is alleged to have been committed. That's so long, but like it's different than politically motivated prosecutions. The goal in the traditional form of prosecution is to hold somebody accountable for committing harm against a person or a community. Politically motivated prosecutions aren't actually about addressing harm that was alleged to have been committed against the community. It's about how can I harm this political opponent, this political rival, to reduce their chances of maintaining access to political power when they have historically used that political power to oppose my political position, right? And so when President Trump came into office, he was very clear. He, I think, was supposed to be sending a direct message to Jeanine Pirro, but like was a public message. And he's like, well, what about Adam Schifter? What about Letitia James? What about James Comey? Like, they went after me. We need to go after them. Like, that's not how our system works. And there used to be such a better separation between the Department of Justice, the U.S. attorneys, and the White House. But now it seems like he says jump and Jeanine Pirro says how high. But that hasn't always been the case. There have been prosecutors in Minnesota and Virginia who are like, no, what you are trying to do is unethical and against my canons of professionalism. so I'm not going to do it. And the example that I was leading up to is in Virginia, the veteran career prosecutor leading that U.S. Attorney's Office was like, no, I've reviewed the case that we have been presented with against James Comey, and there's nothing there. I'm not going to pursue an indictment against him. And so he was probably threatened with being fired, but I think he just resigned. And a good number of people just resigned. And then what ended up happening is President Trump installed these kind of ad hoc U.S. attorneys who were his former personal attorneys, right? Had never tried a criminal case in their life, don't know anything about criminal law. And they were the ones to bring the indictment because they were his yes people, essentially.
Can you imagine? Could you imagine? Will we actually, I want to know what your thoughts are on this. We got a statement from Instagram and it says the governor and AG's beef seems like it should be with the prosecutors and not the citizens. What's your position on that?
Yeah, I disagree. I think their beef should be with themselves. If you're exercising leadership in a state in a way in which members of your electorate think that you could be doing something that rises to the level of the crime, then perhaps you should reevaluate the ways in which you're exercising leadership. And the reason why I don't think the beef should necessarily be with the prosecutors, right? The district attorney, Jason Williams, recused his office and himself. And so there was a special prosecutor appointed. She's a retired judge. Her name is Lori White. Yes, the attorney general can have beef with Lori White. So I will agree with the statement because she was put in a place to oversee the grand jury's investigation. But I think that the primary reflection point should be with themselves. And I study different ways of exercising leadership and to think about what is it that I potentially have done in New Orleans that would cause everyday citizens not to trust the way that I'm exercising leadership. And that's something that can be evaluated, and you can have a little bit more humility. And the ways in which the attorney general was speaking, the way that the governor was like, I'm automatically going to pardon her. Like, what if there was actually truth to the accusations, right? And but like there wasn't even a conversation about it, right? And I think it's the frustration should not be with the grand jurors because I think they just did what they thought was right. They did what they were supposed to do, and what they did was perfectly legal. And that's what's really frustrating is these threats of investigation, these threats of sending to come and have a conversation with these grand jurors. It's just a really unfortunate example of an erosion of a key democratic institution in the state of Louisiana.
Well, I have another question for you. I don't think I thought we discussed this earlier, but I don't think we did. Oftentimes when we hear about grand jury proceedings, we hear these two terms, true bill versus no true bill. Can you explain to us what that means or what those two words mean?
Yeah. Two ways in which the grand jury can vote, as you mentioned, is no true bill of indictment or a true bill of indictment. And so, this indictment is going to be prepared alleging conduct that violates a crime. And that process of trying to support demonstrating to the grand jurors whether or not the indictment is in fact a true indictment, the prosecutor calls in witnesses. It could be detectives, it could be victims, whomever it might be. After the grand jurors have received the presentation of the case at this stage from the prosecutor, they will then basically, look at the indictment and vote on whether or not the prosecutor has called enough witnesses, has presented enough information for them to say, yeah, we think this is actually a true bill of indictment. So if they say and they vote, and again, it doesn't have to be unanimous, at least in Louisiana, and I think that's the case for most jurisdictions, they vote bill of indictment, then that person has been indicted, which means now the very first start of the case has begun. So true bill of indictment means this person is officially charged with a crime, and now there's an active prosecution. If they say no true bill of indictment, it means that there is no indictment. The prosecutor did not necessarily, prove enough information or demonstrate that there's probable cause for the charges, and nothing happens. the person who was under investigation doesn't get a notification that, hey, you were under investigation. The prosecutor presented a case to the grand jury and the grand jury voted no bill of indictment. That person is never made aware of that process. So when we think about a petit jury, their two options are guilty and not guilty. That's at the end of a case. For a grand jury, their two options are true bill or no true bill. And that's just short for true bill of indictment or no true bill of indictment.
Thank you so much for that. So members of the grand jury, as we wind down our August jury duty unmasked, I want to make sure that we are all on the same page about what all of this means for you, right? So in jurisdictions where a grand jury is required in order for a case to go forward, here's what it could potentially look like, right? Several citizens, up to 23 people, as Will told us earlier, can be put in a little room. In that room, day in and day out, for jurisdictions where grand jurors meet every day, they are only really hearing the prosecutor's side. The individual that is being accused of the crime has no constitutional right to be present in that room at the time that the grand jury presentation is happening. Now, remember, y'all, members of the jury who have tuned in the past, we know what a prosecutor is required to do, right? In the grand jury, there are elements, right, that they need to meet. They have to prove, right, that the person that is being accused is the person that committed the crime, right? The location that they're being accused in is the proper location, right? These are different things that the prosecutor has to prove to the members of the community in order for the case to go forward, right? And so day in and day out, they're listening to the police, they're listening to the prosecutors, they're listening to community members that are accusing people of crimes, right? And that's often all they're hearing. And they're making an assessment about whether or not the case should move forward. But members of the jury, if you remember nothing else from this conversation, please remember that if you are called to a grand jury is an investigative body. So you are allowed to ask for more information to make your individualized determination. That's one. Two, it is very important to note that the information that the grand jury is presented with, and we didn't talk about this earlier, but the information that the grand jury is presented with is solely the information that the prosecutor is receiving, right? No one that is entering the grand jury to offer evidence and testimony, except for people who are claiming they are victims of crimes, no one else was actually present during the incident. Everything they're getting, or everything that the grand jury is listening to, is based on someone telling them that someone saw something, based on someone telling them that someone heard something or someone felt something, right? So most of this is not even a firsthand recitation of the events, right? But the grand jurors in the community are not deciding guilt or innocence. They're just deciding whether or not there's enough information to go forward. And if any of you, members of the jury, have ever fought a criminal case, you know that sometimes it's not even about the outcome. As Will consistently tells us, right? Sometimes it's just the process. The process in and of itself of going to court can be incredibly burdensome. So if you are on a grand jury, listen carefully, investigate, ask questions, because you could absolutely change someone's life.
That's such an important message. And when I think about what prosecutors are charged with from their role in the grand jury, they ultimately are required, or they should be putting forth cases that they believe will lead to a conviction at trial. Like, that's one of the standards that they're supposed to have. I didn't say that was the practice, Porsha-Shaf'on. I just said that's like one of the standards. And I think that is a large reason why the Department of Justice's statistics in terms of securing indictments for the last, I would say, like 25 years, with the exception of this last a year and a half, the rate with which they have secured indictments is like 99.9%. I think it's 99.5%. Because you have members in the grand jury who are listening to this prosecutor who appears to be an official, who appears to be knowledgeable about the law, and who appears to be trustworthy, and they wouldn't ask for charges that they think they wouldn't be able to convict at trial. But I say all that to say is that people are still found not guilty at trial.
That's right.
And what gets people really frustrated, and I'm talking about prosecutors who might criticize the Juror Project and are concerned about the work that we're doing, because we know that an informed citizen is an informed juror, and sometimes they like to rely on people not being informed. And it's really a sad state of affairs when educating members of the community about their power, of their presence, and the value of their voice, how that is seen as intimidating to the overall effectiveness of our criminal legal system. But I say all this to say is that just because prosecutors are asking for indictments doesn't mean you have to give it to them, right?
Come on now.
And Porsha-Shaf'on mentioned this. We are laser focused on the fairness of the process. And if members of the grand jury are not aware of their responsibilities, are not aware of their power, then it is our job as the Juror Project to share this information with you all. That's so right. We think that there's these instances where the community can flex more power than it has in the past. And with the current presidential administration and these politically motivated prosecutions, and these prosecutions that are motivated to push a larger administrative agenda, it's been really encouraging to see the way that, as Porsha-Shaf'on says, everyday regular, schmegular, degular folks are resisting this type of oppression on the American people. So when we think about historically resistance in our country, we can start with the 13 colonies. And when the King of England was trying to threaten and take away the liberties of the people who lived in these colonies, right, they resisted. They resisted tyrannical government through many different forms. And one of those forms was through the jury box, whether it was through jury nullification, whether it was through not returning bills of indictment. But we have to understand that resistance is not a single act. It is a collective act of the community. And there are going to be instances in our country where we have to be aware of all of our tools of resistance, because we know that we are so much stronger as a community than we are as individuals. So our intention with these conversations is to give you more information about the power that you already have. But unfortunately, nobody has sat you down to tell you about your power. And unfortunately, there are some prosecutors who are banking on you not knowing the power that you have.
That's right.
If you have found this conversation informative, we hope you share it. It'll be posted on YouTube. We hope that you join us every month to have these types of conversations. And lastly, we hope that you come with your questions. Porsha-Shaf'on and I can have these conversations all the time. We would love to incorporate the things that you're more interested in learning into our conversations. And I want to thank you all for being with us this evening. If you have questions, we got 2 more minutes. If not, Porsha-Shaf'on and I are going to slide on out. Hit us with some questions if you got them. And if you don't, we'll be excited to see you next time.
Absolutely. Also, just to note, we have some new t-shirts coming up on our website. Please stay tuned for that. When they go up, they are really dope. We hope that you love them as much as we do. You'll see us in the streets rocking them. You can rock them too. Thank you so much for tuning in. An informed citizen, as Will always says, is what?
An informed juror.
Come
I
on.
have to give shout out to the designer of the t-shirts, Big Mocha.
Hey!
I don't know if she's laughing or if she's shaking her head, but we have so much great support from Miriam Foy on the communication side, on the design side of a lot of our things. And she's put together some really powerful t-shirts that honor Frederick Douglass and a quote that he has. He says, "A man's rights rests in 3 boxes: the ballot box, the jury box, and the ammo box. And so we are going to be getting some designs of this t-shirt up on the website. And I hope that you all get you on and you rock it with pride. And I really want to end with a huge note of gratitude to Porsha-Shaf'on, to Miriam Foy, and to everybody who has joined this evening's conversation. Thank you.
And to you, Big Willie.
Oh, man. My AOL handle.